If your marriage-based green card case has become unsafe because you are suffering abuse on the hands of your U.S. citizen or permanent resident spouse, just know you do not have to start over. You can convert your pending I-485 application that's based on the I-130 to an I-485 application based on your VAWA I-360 and keep the progress that you have made on your I-485. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. And today, I want to walk you through the step-by-step process of switching your green card case from a spouse-filed petition to a confidential, self-filed VAWA case. If you already filed your I-485 application, that's the green card application, the adjustment of status application, right? But while that application is going on, your relationship has turned abusive or controlling, you may still be eligible to continue your case on your own terms. So let's break that down. According to USCIS policy, if you have an I-485 pending that is based on an I-130 filed by your spouse, and that spouse is abusive or harmful, you can request to convert your I-485 that's based on the I-130 to a VAWA I-485. If you want to do this, there's two ways to do it. One is if you already have your VAWA application filed, then you will use your receipt notice to show that you've already had this filed and request the conversion. Okay, what does this mean? You will then send a notification to the USCIS office that has your file. This, in some situations, may be the field office or the service center. Wherever your I-485 is at that time, you will send a notice to them, letting them know that you have filed your VAWA application or that you have plans to file it within 30 days and that they should keep your application in abeyance, which basically means put it on hold, don't make a decision because I want it to be done through this other process. According to USCIS policy, if you have an I-485 pending based on I-130 filed by your spouse and that spouse is abusive or harmful, you can request to convert your I-485 to a VAWA-based I-485. What does that mean? You initially had an I-130 based on your marriage, and your spouse filed an I-130 for you. Now you can file a VAWA application and ask USCIS to basically change the underlying basis for your green card application. Basically changing it from a green card application based on your spouse filing for you to a green card application based on you self-petitioning under VAWA. So it is really important that you understand how that works. It is really important that you understand the difference there. It's not that you are starting the whole case all over again. Your green card application and whatever you filed with that to show that you qualify for a green card will still be there. The only difference is the reason that you're able to get the green card is going to change from your spouse filing for you to you filing for yourself based on abuse that you suffered from your spouse. When it comes to the mechanics of how to actually make this happen, your first step is filing your VAWA application. But if you're in a situation where there's a I-130 interview already scheduled and you need to stop that interview and make sure USCIS holds off on making a decision based on the spousal visa application, what you can do in that situation where your interview is already scheduled, you know things are not going great, right? You want to get out of this relationship. You don't want your green card based on that marriage. What you need to do then is request for the switch, right? Again, you have not filed your VAWA, but you must show that you're going to file it within 30 days. And you really do need to file it within 30 days. So USCIS will allow you to request for this switch, the holding your application in abeyance. That's the official term, right? Holding your application in abeyance while your VAWA application is decided on. So that would mean if you already filed your VAWA application, you bring proof that you already filed it. If you're going to tell them that you're going to file it within 30 days, you need to show them that you filed it within 30 days, okay? If you say that you're going to file it within 30 days and you do not file it within 30 days, USCIS is going to move forward with that I-130, I-485 application. So it's really important, if you're going to say you're going to file it within 30 days, that you actually file it within 30 days. Okay. With all of that aside, what you would do if you want to make this request is figure out where is your application currently. So if you already have an interview scheduled, you know that your application is at the local field office. So that's where you will send your request. But if let's say your application is still at the service center, then that's where you will send your request. So wherever office has your application is where you will send the request. So either the local field office or the service center that has your application. Now, what do you say when you are requesting this? You need to basically put in writing your request for them to hold your application in abeyance because you are applying for a VAWA petition, or that you have already filed a VAWA petition. With that petition, with that request, you need to make sure you include the receipt notice for the different applications. So the I-130, the I-485, you want to make sure you're including the receipt number, the receipt notice, just so USCIS can figure out what application that you are asking them to take action on. And then if you have already filed your VAWA application, again, this is the preferred method, right? If you have already filed the VAWA application, you want to include the receipt notice for that VAWA application when you are making the request to hold the application in abeyance while the VAWA is approved, okay? It's really important to note here that timing matters when it comes to making this request. So that's why I say if you can get that VAWA application filed before making the request, that would be the best practice. However, if you are in a situation where, like I said before, your interview has already been scheduled, you and your spouse have basically ended the relationship, you don't want to move forward with it because of the abuse, you are now in a position where there's an interview scheduled, you can't attend the interview with your spouse, but you also know you want to file a VAWA petition and you qualify for a VAWA petition. In that situation, you need to let USCIS know immediately that you want that case to be held in abeyance while you file the VAWA application, and that you plan on filing it within 30 days, okay? What we typically do in our office when that is the situation is that as we're filing that VAWA application, we are also including the receipt notice for the I-130, the receipt notice for the I-485, and within our VAWA application packet, we are requesting for those two applications to be held in abeyance. Remember, you already sent a notice to USCIS letting them know, hey, please hold off on making a decision on this case because I'm going to file this VAWA application. But also, when you're filing the VAWA application, you also want to make that request within your packet just so everything can be, everything can get to where it needs to go. It's really important that we, as the people petitioning for things, that we are giving USCIS as much information as possible about what we are requesting of them. So in this situation, you want to make sure that not only do you send that to the field office or the service center that has the applications pending, but also when you're filing that VAWA application, that you are including your request under that as well, just so you can cover all of your bases. Like I said before, timing is everything. The sooner you notify USCIS, the easier it is for them to match your files and prevent any confusions or delays. Listen, there's been situations where people just wait till last minute to notify USCIS and they already scheduled the interview. Like, you are day before your interview trying to tell them that you want to hold this application in abeyance. They may not do it. Right? I've seen situations where people try to do it the day of the interview and USCIS says no. So it's really important that you do this ahead of time. And remember, the reason that VAWA exists is to give protection and provide safety for people that want to file for VAWA. So if you are in an abusive relationship and you're waiting the day of your interview to request this and your spouse is there with you, that is just asking for trouble with the spouse that is abusive. So that's why I always say, file it ahead of time, make that request as soon as possible so that USCIS can just cancel the interview without giving a reason. Remember, confidentiality is huge with our applications. So they're not going to send you a notice saying, hey, we're canceling the interview because the beneficiary is going to now file for VAWA. They're not allowed to say that. They will just say, based on, unforeseen circumstances, we had to cancel your interview. We'll let you know when we reschedule. Right? That's what they're going to say. They are not going to mention the VAWA application. So if that's something you're afraid of, don't, because of that confidentiality clause when it comes to VAWA petitions. By the way, if you are finding this video valuable, please make sure to hit the like button, share this video with anyone you think will find it helpful, and remember, ask me questions in the comments. If you have questions about VAWA, about the whole process, feel free to ask me in the comments. And actually, tell me in the comments, what is a question you have about VAWA that I haven't answered yet, so that I can make a future video answering your question. When it comes to VAWA applications, I will always end with this. Your safety comes first, and VAWA recognizes that. Like I said, USCIS is not going to send a notice canceling the interview, letting your spouse know that it's because you filed for VAWA. The privacy part of it is all about keeping the abused spouse safe. So when you're switching your case from a marriage-based case to a VAWA case, we take steps to protect your privacy at every single stage. One, we can use a safe mailing address, one that your abuser cannot access. So for most of our clients, our office is their safe mailing address because, again, they may still live with their abuser may still have access to their mailbox and their mail. So having a safe mailing address is a must to keep you safe. If needed, we can request that USCIS hold your interview until your VAWA petition is reviewed and approved. Again, that is the whole point to this video on how to request that. Because again, if we are starting your VAWA process, if we are saying that this spouse is abusive, the last thing we want is for you to go to an interview with that abusive spouse, or to go to an interview where the spouse doesn't show up and USCIS uses that against you. So we want to make sure that we are not doing anything that will jeopardize your ability to get a green card. So making sure that you are requesting for your interview to be held until your VAWA petition is decided is very crucial to keeping you safe. If you already have an interview scheduled, notify the officer in advance that you want to switch to VAWA and remind them of the confidentiality under the law, because the confidentiality part of VAWA is so crucial to the law, because they cannot tell your spouse that the reason they're rescheduling the interview is because you filed for VAWA. That is not allowed. You can actually sue USCIS if they do that, because they violated the confidentiality clause under this law, okay? It's really important to know that if your interview does move forward, you want to make sure that you are informing and as safely as possible the officer about your intentions to apply for VAWA and that you would like to not move forward with the interview, especially if your spouse does not show up to the interview. Okay, it will be the safest scenario is if your spouse does not show up to the interview, you can let the officer know, hey, I am applying for VAWA. Please hold off on making a decision while I go through that step of applying for VAWA. You may want to, in that situation where your spouse is not showing up, you may want to bring some evidence of the abuse just so the officer understands that you are taking those steps. In our office, we do everything in our power to make sure that that I-130 interview with your abusive spouse does not move forward. Because again, the goal is your safety and making sure that you are not in a position where you have to now go through an interview and are afraid that your spouse is going to find out that you want to file for VAWA or that you don't want to move forward with the case altogether. And that we have seen in practice has led to further abuse. So really important that we make sure that the abused here, you applying for VAWA, are safe at every single stage. So that's why this whole process of holding an application in abeyance and not scheduling interviews for the I-130 when there's a VAWA application pending is really important and does keep people safe. I want to end this video by saying this. There is a confidentiality clause when you're working with an attorney. If your attorney, I'm working on an I-130, I-485 application for you and your spouse, me as your attorney cannot also help you with a VAWA application because there's then a confidentiality issue. There is a loyalty issue because, again, as the attorney on the I-130, I-485 application, I represent you and your spouse, right? So if I now represent you on a petition where the accusations are against my other client, your spouse, it's just not, it's an ethical issue, right? It's an ethical issue. It's unethical for me to represent both of you and then also represent you on a VAWA case. In those situations, if someone comes to me while our I-130, I-485 is pending and says, oh, I'm being abused by my spouse, I want to apply for VAWA, I withdraw from the case because I can no longer move forward with an I-130, I-485 application knowing that there is a controversy in the case, meaning that one spouse is abusing the other spouse and the other spouse is looking to get out of the relationship and file a VAWA application. I just ethically cannot stay in the case. That does not mean that you don't have a case. I typically refer people out to get a consultation from another attorney and figure out whether they qualify for VAWA. It's not my call in that situation. So, and I also get calls from people where they're in that situation and their lawyer referred them out because their lawyer can no longer handle their VAWA case because there's now an issue between two clients. So it's really important to note that your I-130, I-485 lawyer should not be your I-360 VAWA petition lawyer because of just the confidentiality and all the ethical issues that can raise. So you want to make sure that you want to make sure that if you are in a situation where you want to file for VAWA or you want to explore whether you qualify for VAWA, that you are doing a consultation with another lawyer that is not connected to the I-130, I-485 case that you have already filed. If you're in a situation where you are considering filing for VAWA, but you also have an I-130 and I-485 pending, and you're not sure what to do next, how to move forward, please feel free to schedule a strategy session with me. With the strategy session, we can talk about what your situation is, what your goals are, and the steps that you can take to achieve those goals. Remember, part of that strategy session is looking at your situation. So make sure you bring your receipt notices. If you have an interview notice, bring those with you. Make sure that I have access to them to look at them before the strategy session, just so I can have a full picture of your situation, so that when we're talking, I can actually give you personalized legal advice on what your next steps can be. If you want to schedule that free strategy session, please feel free to go to my website, lilylegal.com, click on Contact Us, and then select a date and time that works best for you for us to chat about your situation. Remember, you don't have to start over. Let's pick up where you left off and do it in the safest way possible.